And the first thing I wanted to talk about is what we are really about in special education is developing an educational program that confers what's called a free appropriate public education, or FAPE. Now that, of course, is our essential charge. We have to develop IEPs that confer a FAPE. Well, what exactly does that mean? Because as a slide later on will say, that was not defined real clearly by Congress when they originally passed the law back in 1975, when it was the Education for All Handicapped Children Act, and we referred to it as PL 9142. Of course, the name of it was changed in 1990 to the Individuals with Disabilities Education Act. But interestingly enough, in the entire time since 1975, the definition of FAPE has not changed. It's the same thing as it always was. And that's what we're going to be talking about a little today. And specifically, what does that mean in terms of the educational benefit that we have to confer on the children with whom we work to actually develop a free, appropriate public education? That's why we talk about how ambitious, how we can ambitiously define FAPE. Now, what FAPE has meant since the passage in 1975 is the IEP that we write must be reasonably calculated to enable a child to receive educational benefits. That doesn't mean we have to provide the best possible education, but we need to provide an education that's specifically designed to meet the child's unique needs, supported by services that will allow the child to benefit from instruction. Back in this, I believe it was 1980, the Draper v. Atlanta case said an IEP must be reasonably calculated but not guaranteed to provide a child with some educational benefit. So that's still not real clear, but what is clear from that definition is the IEP is not a guarantee of success, but it's a guarantee that we will provide, we will develop an education that's reasonably calculated to provide a child with some educational benefit. Now, that becomes the question. What does that mean, some educational benefit? And that was answered way back in 2014 in a case that began at a district court level in Colorado called Endrew v. Douglas County School District, and that's the case that went all the way up to the Supreme Court. Now, the question we want to answer, we want to grapple with today is what standard or level of educational benefit has to be afforded to students with disabilities. In other words, when we develop that IEP, what level of educational benefit are we supposed to be conferring on the children with whom we develop the IEP for? Now, this is the way the idea defines free, appropriate public education. And it's really a procedural definition. This is what the law has said since 1975. FAPE consists of special education and related services that are free, that are provided at no cost to a child's parents, that meet the standards of the state educational agency. So that's kind of a nod the federal government gave to states, because states really have the prerogative to educate and legislate over education of all youngsters. And what that essentially means, in reality, what it means, if your state has certain parts of the idea where they actually extend the rights of youngsters with disabilities beyond that in the federal government, you have to honor those. So for example, Article 19 is your special education law. It's essentially the same thing as the idea, as the Individuals with Disabilities Education Act, which of course is a federal law. Article 19 is your state law. They're virtually the same, with the exception of a couple areas. One of those areas is age of transition programming. So the federal government requires that you provide transition programming when a child is 18 or 16. But Article 19 requires it at 14, yeah. So you have to follow the state law with respect to that. But in other respects, your law, Article 19, is the same as the federal law. Now, one thing a state cannot do is they cannot provide less rights to a youngster with disability. They can provide more, like you do in saying transition services have to be started at an earlier age. But Indiana could not say, well, we don't think we need to really start transition at 16, so we'll start it at 18. You couldn't do that because you're offering less than the federal government does. So that's why they have the meet state standards. Now, it includes appropriate preschool, elementary, or secondary education, and it's provided in conformity with the IEP, or with the student's individualized education program. So that's a real procedural sort of definition. That is what we have to do. Now, in a case in 1982, in the very first case heard by the Supreme Court in special education, which was the Board of Education of the Hendrick Hudson School District v. Rowley, the Supreme Court was asked to define, well, what does that mean, FAPE? Because it's not really clear from just the procedural definition what it is. So, Supreme Court, can you kind of define it for us? And what they did is not only came up with a procedural definition, but they also added a substantive component to it. They said essentially, a school district provides a free, appropriate public education to a student with disabilities if it develops a student's IEP in accordance with the procedures of the IDEA. That's what the federal definition is. And if the IEP is reasonably calculated to enable the child to receive educational benefits. So that was in 1982. Actually, I was getting my master's degree in 1982, and I remember professors thinking, oh my goodness, the Supreme Court could say it was unconstitutional, say the idea was unconstitutional. Well, they didn't, and what they did is define FAPE in a new way for us that added this substantive component. In essence, what the High Court did in Rowley was when they first addressed the FAPE requirement, they noted that the federal special education law guarantees that all eligible students with disabilities will receive an IEP reasonably calculated to enable to receive educational benefits. Now, kind of focus on that. Educational benefits. What exactly does that mean? Now, well, the Supreme Court considered a number of things in this case in evaluating if a school district meets that standard, including least restrictive environment, other considerations such as full integration into the regular classroom, whether a child was receiving passing marks and advancing between grades, and importantly, and this set the stage for this new Supreme Court case that we'll be talking about, is it set the stage for the High Court again to review the FAPE standard in Endrew. In other words, because what the court did in Rowley is they declined to establish any one test for determining the adequacy of educational benefits that are conferred by children with disabilities. Because essentially what they said, the case Board of Education v. Rowley involved a young girl named Amy Rowley who was profoundly deaf, and she did qualify under then the Education for All Handicapped Children Act. But when the court had to look at the IEP to see if it was reasonably calculated to provide educational benefits, well, Amy was a very bright child, academically able, and had an IQ variously measured as between 125 and 140. So they didn't really have to answer what exactly this test of educational benefit is. So they said, we're not going to develop a test that confers upon all children a definition. We're going to confine our analysis to Amy's situation. Now, they also found that for children with disabilities who receive instruction in the regular classroom, this would generally require an IEP reasonably calculated to enable a child to achieve passing marks and advance from grade to grade. So in other words, that meant for a FAPE, for a child with disabilities in the regular classroom who was doing very well, if they were able to cognitively benefit from regular classroom instruction, what a FAPE would mean for those children is that they would be passing from grade to grade and doing well in that respect. But of course, in a note, they also said, now remember, this only applies to Amy. Well, the problem came in then when we're trying to apply this standard to other students who do not have 140 IQ or are not doing that well in regular classes. So then the question would be, how can any one test or a type of analysis apply to all students with disabilities who have differing needs, strengths and weaknesses, and classifications? So what does some educational benefit mean for youngsters with various types of disabilities? Did you want to take over for a little while, Dave?
Yeah. And so let me tell you about this. Let me talk to you about this case. And before I go, let me just give you a brief introduction of who I am. I too was a classroom teacher, taught kids with behavior disorders, intellectual disability, or we used to call them mental retardation. Sorry, I'm dating myself. And then for many years, I was a due process hearing officer. I'm actually a retired due process hearing officer, which I don't look like a retired due process hearing officer, because most people who start as hearing officers are retirees in most states. So, but yeah, I did that for 10 years. And so, and he's a hearing officer also. So we're going to talk about it from different perspectives. But I want to lay this into foundation and talk about this. The Rowley case was 1982. Public Law 94-142, which was passed in 1975, we got the regulations in 1978. That case was in 1982. Put that in historical perspective. It was an access act, getting kids in the door. And that case was really the very first case that we had relating to trying to determine what was going on, relating to what do you really mean by appropriate. Since 1982, things have changed in education. You may be aware of this. We had in 1985, we had a nation at risk. You didn't realize the nation was at risk in 1985. Some of you, it was an interesting read. Then, since then, we had Goals 2000. Then we had America 2000. Then we had No Child Left Behind. And then the Elementary and Secondary Every Student Succeeds Act of 2015. So there's been some changes, and as a result of those changes, there's been an accountability change for educators generally. Because I'll give you background. When I was a teacher back in the late 80s or in the 90s, kids with disabilities did not take the state tests. And I did not know this because I was an equivalent resource teacher where kids came to me for half hour to 2 hours every single day. But during testing week, I had all kids all the time because they didn't take tests. In fact, my district was racing to identify kids as eligible so that they would not take the tests. And there were some other kids they also said who were not found eligible. They just said to them, just stay home. It's not going to be a good week for you. So it was a very different, try that now. Just try that now. Write that down. Okay? I share this with you but the accountability measures for what educators are expected to do has changed dramatically. So it's not just in special ed, but educators in general. We haven't had a concomitant change in special education. So remember, the Rowley case was very much a gateway access, getting kids in the door, just trying what's going on. Okay? Since then, education has changed. And we needed some clarity on this. As Mitch nicely articulated on this, we had a very bright individual who was passing from grade to grade. And I'm sincerely hoping that if you've got a kid with an IQ in the 130s in your secondary class, that they too would pass from grade to grade. I'm just putting it out there. But she was passing from grade to grade and doing fairly well. But for kids, and many of us, when we got into special education, we were living with the Rowley case. We were living with the Rowley case where we had, one of the tenets of the Rowley case was, had you followed the procedures of the law? And the big thing is, do we meet the timelines, and do we have the right people in the room? I know many of you have special ed directors who hound you to make sure that you have that going on. It's a direct result of that Supreme Court case. Right? Now, I wish we didn't have to be talking about Supreme Court cases relating to kids with disabilities. I wish that everyone just did what they were supposed to be doing. But you have to remember that special education is a field defined by a law. And because of that, there are interpretations. And we're also dealing with issues of what we mean by appropriate and what is meant by appropriate. When I was a building level administrator for high school, there were kids who wore clothing that I did not feel it was appropriate. I don't have pictures, and I'm not, just let your mind wander, and yeah, they wore that. So it's really, or tried to, or not wear it. And so we have different we have different expectations, we have different views of what's appropriate. So that's why there's been a lot of litigation relating to this, right? So I want to give the foundation for how we got to where we are. Many of you got involved in the field as part of the Raleigh case. This is going to change things, though. So let me give you the background on the Endrew case and give you some sense of this, right? His full name is Endrew. I'm going to refer to him as Drew because that's what his parents call him, right? But Drew is a student with autism and received in-district services from kindergarten through 4th grade in the same school district. He attended schools in Douglas County, Colorado, school district just south of Denver. And as a part of that, he had a sweet disposition, which is nice. Those of you who've written reports on kids, isn't it nice to write a sweet disposition? Yeah, it's like that. There's another one we often write that we may not think of as a positive, attends school regularly. We often write that one as a positive, whether we actually think that's a positive or not, okay? Peer concerns, yet difficult multiple behaviors that inhibit his ability to access learning in the environment. Okay? Some of the problems that he had, some of the behaviors that he exhibited, is that he loved ponytails. And some of you have longer hair than, they have longer hair than you. Longer hair, he would grab their ponytails. You could see the whites of his knuckles. He would not let go. He failed bus multiple times. We don't do a really good job of teaching bus. We often, the response we do when kids fail bus is to kick them off for 3 days, and then come back. We don't actually teach bus very well. We actually do a really poor job of this in many places. We don't do a good job of this. The other thing, and I'm not going to demonstrate this for you, is when he would get really frustrated, he would stand up in the middle of the classroom and urinate on the floor. And so they actually had to remove the carpets from his classroom as a result of this. So behaviors, there were clearly some behaviors. There were some behaviors that he was exhibiting, right? Right? Climbing over furniture, grabbing other students, elopement, fears and aversion to flies, spills, and had restroom. He was really afraid of flies. My dog is the same way. A fly comes in the house, he cowers. We know something's going on, but yes, he would not even, Drew would not actually come into the classroom if there was a fly, or if there was a fly, he just would run away. And so things like this. So he had some behavior issues. Wait, there's more, okay? But it basically was interesting is he attended the same school. He attended the same, basically, and had the same program in the same building. He's argued that his academic and functional problems had essentially stalled. And this, you can see, this is from the parents' brief on this. Largely, basically, they carried their same goals. This actually could save you guys a lot of time. Basically, he had the same goals from year to year to year to year. Just think how much time that would save you just by doing that. Things like this. There was one time, though, he had different goals, and it was actually not different goals as they reordered the goals. So that's another time. They're thinking about time-saving techniques. That's one you could try, okay? But the other thing is, largely carry the same basic goals and objectives from year to year, from kindergarten all the way through 4th grade, and without any demonstration of meaningful progress. One thing that you guys know about IEPs, in order for them to work, you actually kind of periodically have to check what's going on. They were not taking progress monitoring data on him. And so another time-saving technique for you. Okay? So you didn't think that's what you're coming here for, but that's what I'm going to give you, some time-saving techniques. They were not taking, and they were also, here's another thing they were not reporting his progress to the parents. You guys know that as a requirement. Federal law says very specifically about this, that is kids with disability, parents with disability, of children eligible for special education are to receive notice at the same frequency as non-disabled individuals. Kids get their report cards and reports, things like this. So that's why we do this. Parents were not getting this, right? So when the parents basically got this, they looked at the same IEP that he was receiving basically from kindergarten through 4th grade. They then, when they were going into 5th grade, they said, we're going to enroll him at the Firefly Autism House, a school that just for kids with autism that was in southern Denver that they wanted to send him to, and just kind of, okay? Where he made, actually in the first year, he actually made significant progress. And so they were arguing that he was actually, his disability was not preventing him from making progress. But at Firefly, he was making progress, and it permitted him to actually make these interventions, also allowed him to make academic progress. So not only were they stemming the tide of his behavior issues, and anything also about behavior issues is that you might be aware of, as kids get bigger, their behavior issues sometimes increase. Write that down. Right? But it's interesting about this, as he was getting bigger, when he was in kindergarten, his behavior, as he was getting bigger, this is sign language for kids getting bigger, he was actually getting bigger, and what's really interesting about this is that his behaviors were actually getting worse. Right? But the Firefly Autism House, in 5th grade, in his first year, his behaviors actually improved. So they were able to demonstrate that this could actually happen. Right? The facts, let's go back to the facts, in 5th grade, the district, again, proposed to implement basically the same IEP that he had in 2nd grade, 3rd grade, and 4th grade in 5th grade. That's what they were going to do, right? These time-saving techniques may not always work out as a benefit to you, so just there's a corollary here, okay? So they placed him in the out-of-district placement and filed for suit for tuition reimbursement. When I was a hearing officer, I frequently heard tuition reimbursement cases. And tuition reimbursement is something that is available as a check on the system to make sure you do what you're supposed to be doing. The same thing with independent educational evaluations, to make sure that you're doing what you're supposed to be doing. And it doesn't exist for non-disabled kids, right? For instance, my son in 3rd grade had a teacher who had basically retired several years before, but was still showing up drawing a paycheck. Okay? His 3rd grade curriculum consisted almost entirely of that effective reading method that we all know as SSR, sustained silent reading. But he did not have a disability at the time, and so there was no check on the system for what we did, but he loved 3rd grade. He talks about 3rd grade as the best year of his life. He just recently graduated from college. But what's interesting about this is basically he came to the class, got in a beanbag chair, and you sat and read, and if you were quiet enough for a while, she'd motion you up and give you candy. Okay? We complained, but there was no right to check the system as there was for Drew. There's a right to make sure that he's not just being warehoused. Because think about, again, how education has changed for kids with disabilities. My first year of teaching, I remember this very specifically, my principal said to me, I don't care what you do down there, just keep them quiet. Actually, we taught some things too, quietly, but we did this. But you can see how education has changed. But as a check on the system, it's available for parents to make sure districts don't just warehouse kids. And it only exists for kids who are eligible for special education. Doesn't exist for non-disabled kids. Right? So keep more on this, all right? So about this. So the parents, let's talk more about this. The parents file for due process hearing. I'm not a fan of due process hearings. I haven't had a call about a due process hearing since about 11:30 today. So I'm right now involved in 18 of them. So I retired, and now I work with districts when they're sued. It's an interesting. It's easier being the consultant than being the hearing officer. Right? But they lost at the due process hearing level, and basically the hearing officer said the district was doing exactly what it was supposed to be doing. Right? So they went to the circuit court. And think about this: if you're a district, you go to a hearing and you win. What do you think? Your poop doesn't stink. Yeah, okay? Okay? It's an educational term, okay? But you think that everything's fine, so why should we change? So the parents then filed in circuit court, the court just above the hearing officer level, and the district won again, right? This is great. You don't hear about this happening too often, all right? So the parents then filed in the 10th Circuit, which is the court just below the Supreme Court. And the 10th Circuit Court also said the district's doing just fine. So you think about this, right? They interpreted Raleigh like other circuits, establishing a standard requiring educational benefit merely more than de minimis. Okay? What is merely more than de minimis? Here's a visual reference. About this much. The best example I give you is yesterday I flew, and I had a whole bunch of problems flying to get here. And so I actually don't drink much when I'm on planes because I don't like to have to get up and just do that. So I was by the time I got here last night, about 12:45, I was grossly dehydrated, all right? So someone had come up to me with a shot glass filled with water. Would I have drank it? Yeah. Would I have benefited? Yeah, about this much. That's actually the low standard. That's the low standard that we're talking about in some of these districts. I live in Carlisle, Pennsylvania, which is the home of the U.S. Army War College. Every single year, it's a town of about 20,000 people. Every single year, we bring 300 colonels from around the nation to the U.S. Army War College. And the stories I hear from how low the standard is in other states would scare you, would make you cry. And many of these families, because there are different states have different standards, we actually have a fairly high standard in Pennsylvania. Many of these families choose to keep a spouse there while the other spouse is either deployed, goes to Iraq, Afghanistan, or the Pentagon from there. And so it's a really interesting mix, but the stories about how low the standard really is very, very scary. And so many of these kids were getting the equivalent of shot glasses filled with water of educational benefit each year. And back to what I was basically, when I was told in the early 90s, keep the kids quiet. So you can see this, right? The 10th Circuit further noted that so long as Endrew made some progress. Everybody getting this one down? Some progress, okay? He made progress on one of his goals in 2nd grade. There was no evidence of really any other progress, first because they weren't taking data. Again, that time-saving technique I was pushing earlier. They weren't taking data, but he was made some progress, which posed a significant problem. But he made some progress. So therefore, they felt that he met the letter and spirit of what the law required. I'm not making this up. The facts are there. All right, more. Okay. So they actually appealed the court. The parents appealed to the Supreme Court. And whenever you appeal to the Supreme Court, it's dangerous. You don't know exactly what's going to go. You don't know how this is going to be heard. It's an incredibly it's a risky thing because the decision by the Supreme Court is binding on all the United States and all of its territories. You don't think about the territories, but it's also binding. I was in Guam in December. It's binding on Guam. You ever go to Guam? It's long. There's no very easy way to get there. Okay, it took 42 hours to get home. Right? But I share this with you, but this is the question. And this is the essential question that we need to ask in special education. You're going to go to some great sessions here, and I'm really excited about what they put on here. But I think this is the best session because you're going to talk about what is the essential thing that we're doing in special education. Is what is the level of educational benefit school districts must provide for kids in order for them to receive a free, appropriate public education? What is our basic response? This is our basic responsibility. We can talk about all sorts of things, but this is, as special educators, this is the basic responsibility we have. And this is what drives all of what we need to do on a daily basis. And because of that, this is something that's important. And we needed this case. We needed this case. First, we've been living with the Rowley case from 1982. Some of you don't even remember 1982. Just don't raise your hands. That just pisses me off. All right? Okay? You were in graduate school? Graduate school, yes. I had not yet met my wife. So I've been married over 32 years. So that's how I date everything by that. Right? It's my first wife. But it's interesting about this, or starter wife as I call her. But it's interesting about this is we've needed a case because that standard was for a kid with a really high IQ, but also education had changed since then. But also the states had been interpreting the cases, the various circuits had been interpreting this very differently. You may not be aware of this, but the states have been looking, I'm going to stand here, but some states basically had a substantial standard. Some states had just basically any kind of progress. Okay? I live in Pennsylvania, which is part of the 3rd Circuit, which is Delaware, New Jersey, and Pennsylvania. And we had a fairly high standard of what was expected. And if we have a high standard, that bothers me about the rest of the states. But I've been doing some work lately in Mississippi and Arkansas, which had, I think it's like any progress kind of standard. So I'm picking on the states, but you could think about this as really very, very low standards in some places. And so that posed a problem. Okay? So you want to take over?
Sure.
Yeah.
We're right over here. We're just a little bit of benefit is fine. Where David is way up in the meaningful area, well, this is what happened in the Rowley case. As David was saying, is the Rowley court essentially said they were looking at Amy Rowley, and they were essentially saying, well, she did get benefit. she was passing from grade to grade. They also said this doesn't apply to all students, it only applies to Amy, but they use that term educational benefit. And different circuits were interpreting that in different ways. Like we were saying in the Fourth Circuit, any little bit of benefit will work. David's circuit was saying meaningful benefit. The Tenth Circuit, which is the case in which the Endrew case was heard, it was the court in which the Endrew case was heard, they were down in this area. In fact, they used the terminology merely more than de minimis, which in an argument before the Supreme Court, the Solicitor General said that essentially means a little better than nothing. So that was okay for Endrew. Well, as David said, when it went to the Supreme Court, they gave us a new standard. Now, the question the Supreme Court was really looking at was what exactly is educational benefit? When it's provided by a school, does it have to be more than the Tenth Circuit said, merely more than de minimis, in order to satisfy the FAPE requirement? Well, again, the Congress never really defined it in a way that was much beyond procedural. So it's really been up to the Supreme Court to define the level of educational benefit. Now, there's some quotables. It was a very interesting decision. And one of the things, and we'll talk about it later, there's a website. If you go to Google and put Endrew Supreme Court blog or SCOTUS blog, you'll get to the official Supreme Court blog on the Endrew case. And it's very interesting. One of the things you can get to is OIA.com. Under oral arguments, if you click on that, you can actually hear the oral arguments in this case. And what we did is we put a number of very interesting quotes from the Supreme Court justices. But essentially, David and I were both got to hear the case, which was very interesting. When you're at the Supreme Court, you just have to, when you want to hear a case, you just kind of have to line up in the morning, and we both lined up very early in the morning and got in to hear the case. And it was really fascinating. As David has said a number of times, it made him proud. It will make you proud of 1/3 of the government when you hear the Supreme Court. But it seemed real obvious to us that most of the Supreme Court justices were asking questions that seemed to favor the parents rather than the school district. And here's just a snapshot of a few of the things they said. One of the things that Chief Justice Roberts said to the school district advocate is, you're saying, in essence, you're reading the law as saying some benefit, and the other side is reading it as saying some benefit. And he gave emphasis to the fact there was some benefit. Everybody laughed because, as David said, that's kind of a Supreme Court joke, is there was not a lot of difference, but the difference in what they accented. And it basically came down to what exactly is significant educational benefit. Well, right early on in the argument, Chief Justice Roberts said, it's more than simply de minimis. It suggests you just can't look at something and say, aha, here, that was helpful because the whole package has got to be helpful enough to allow the student to keep up with his peers.
Now, what's interesting about this, and Mitch and I were there, and it was really, if you ever get the chance to go to see a Supreme Court case, I highly recommend it. The hard part is you have to line up at butt ugly early to get in there. And we had some friends who were there who were line sitters, who had paid line sitters to do this, which I've since found is illegal. And so, but you were there at 5 in the morning. Mm-hmm. I was there at 5:20. I didn't know he was in line because it was in January. It was like 28 degrees. It was dark. It was windy. It was kind of rainy. You stand in your jacket kind of like this and just stand there freezing your butt off. And then waiting to get in line. He was like only like a few people in line, but it was dark, it was cold. So I'm just complaining. I'm still warming up. But I share this, but you really should go. You really should go because they are very well prepped. They are very well prepared for this, and they're spot on. But what's interesting about this, you can see significant whatever. You see this from Chief Justice Roberts, who, whether you agree or disagree with him, is an incredibly articulate individual. And one about him is he was really wrestling with, and you'll see this in another quote later, is what are we going to do for kids who are not going to make a year's worth of progress? Because the parents were essentially arguing that all kids need to make a year's worth of progress. And I don't want to rain on your parade. There are some kids out there that no matter how hard we work with them, no matter what we do, they're not going to make a year's worth of progress. Okay? I'm not just the reality of the situation, just things like this. Like, for instance, my brother-in-law has identified as having profound intellectual disabilities. He's 61, 62 years of age, younger than you. And so, yeah, it's his birthday. Yeah. And so, but he needs help toileting, he's nonverbal, he knows maybe 10 signs. He's not going to make, I could work with him 90 hours a week every week for the whole year. He's not going to make a year's worth of progress. And so the rally standard was, they were really wrestling with this as a part of this. What do we mean by significant? And what do we mean by this, okay? And going back, let me just go back one for a second so you see this, okay? But they were also worried that if they raised the standard too high, because again, a visual reference, I'm in line for visual references today, that basically, remember the low standard of the district, because remember, they'd won at the hearing officer level, they won at the circuit court, they won at the 10th Circuit, they were down here. Parents were asking for a standard up here. And Justice Breyer was worried if we raised it up to here, the amount of litigation that would result as a part of this. Because districts were not prepared to do that, and not really had to do that in the past. So it really did. So you can see they're looking at it from all different angles and trying to really understand what's going on. But going back to this, okay? Putting aside the words, are the outcomes appropriate? Do you think the lower court needs a kick? Justice Alito was really, really hot on this as a part of this, as was Justice Ginsburg, right? And this is the attorney for the parents. The attorney for the parents who's basically arguing, okay? They think they need a kick. I mean, remember, the district was here, the parents were asking for here, right? And so there was a chasm. There really is a chasm that existed between the two, okay? Are by and large following the standard, basically, and the Solicitor General is the attorney for the United States who was arguing basically the same side as the parents on this one and weighed in very nicely on this. Have a disjoint between educators are doing and the courts. And you could see this if you look at how different courts are doing this across the nation. And it really shouldn't matter where you live, the education that your child receives. And it was very, very different from state to state, okay? Very, very, very rare, very, 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 very rare cases that makes it into court is not being properly reviewed. They're not reviewing these things. And there is a very different kind of, I'm going to use very a lot tonight. So, but a lot of very different kind of different levels of expectations and parent, right? Right? Equal opportunity would be, don't understand what equal opportunity means when equal outcome is not practical. They were really wrestling. They were truly wrestling with the concept of there are some kids who are going to clearly make grade level progress and kids who would not make grade level progress. I mean, again, these are individuals whose special education is not their background, but they were wrestling with the questions. I think if we were to lock ourselves in a room and buy ourselves some alcohol, we would come up with some of these same questions, right? But it would take some gin, but there's things like this, right? Is equally challenging curriculum on the academic side in terms of functional and developmental goals. Again, is that the attorney for the parents? But is trying to push this forward and move forward, okay? Justice Kagan, an incredibly articulate individual. For those of us who have not some feeling about the words equality is a poor fit, the statute, and its focus on individualization, what would you say? How would you describe what you think is required without focusing on equality? They were trying to talk about, I mean, they all understood that the I of the IEP stands for individualization, individualized. We need to tell some school districts that. But we also need to emphasize that also equality is a part of this. That equality doesn't mean that everyone necessarily gets the same thing. And they were wrestling with this and dealing with this, and you could see there was palpable discussions on this, all right? So, okay. More quotables, I'll let you do the decision, right? The Council for the Solicitor General. FAPE is a program that is aimed at significant educational progress in light of the child's circumstances. So now there's some reality that there are kids who might not achieve at the same level as each other, which we all know. But the society doesn't really quite understand what special education is. I mean, I've recently been doing a study of what people think special ed is. I'm working with school board members, which is kind of interesting because school board members often, there's another right thing you can write down, often don't know anything. And so I'm working on something right now for school board members as a part of this. And so I survey school board members what they know about special ed. And I say, what is the biggest category in special ed? And they say 80% of special ed is Down syndrome. Then I know you'll appreciate the numbers. 80% of special ed is Down syndrome. Another 5% is kids with visually impaired or blind. They understand there's a difference. There 5% are deaf. 5% are kids with autism. 5% are kids with physical disabilities. And then there's 5% other. Now, if you total that all up, it adds up to 105%. So those you're keeping track at home. But that's actually in line with what society thinks. I mean, I've been to increasingly a lot of weddings lately. People on their multiple weddings, things like this. And I tell them in special ed, oh, you work with kids with Down syndrome. That is the standard response I get. And because society doesn't understand what we do. But I was really impressed that they were understanding that there is a difference. That there is a difference out there. That some kids will not necessarily make grade level progress. But that there are some kids eligible for special education who would. And that we need to understand this, all right? Justice Ginsburg, who is amazing when she questions, she looks frail, wanted to know how that different from Mr. Fisher's approach, especially since Mr. Fisher and Gornstein both are arguing on behalf of Endrew's parents. Remember, the Solicitor General was arguing on part of this. Okay? Both thought that FAPE required grade level competence for students who are at the regular classroom or in the general curriculum. So the parents are basically arguing, back to this reference, they wanted the kids to make grade level progress each and every single year. I think that'd be wonderful, folks. I'd be in support if that could happen, all right? But no, all right? That which drew a rebuke from Chief Justice Roberts, who is spot on and things like this. We're talking about someone who I think you'd agree that standard does not apply. Let's go back to Drew. Had an IQ of about 80. Diagnosed very young as had autism, also had significant ADHD, and all those behavior problems, which I think is actually much more reflective of what you're dealing in special education than Amy Rowley. Much more reflective. That's also why we needed this case. That's also why we needed this, okay? The justices were reluctant to set too stringent a standard, but neither did they like the standard used by the 10th Circuit, all right?
The U.S. Supreme Court vacated the lower court's decision in the Endrew case and remanded it. So essentially what that means is they said, we think you got it wrong, you have to redecide this case, and you have to use our new standard of educational benefit to make this decision. And the new standard, the one we now live with, regarding the amount of benefit, educational benefit, our IEP should confer on youngsters with disabilities is this. Was the student's IEP reasonably calculated to enable a student to make progress appropriate in light of his or her circumstances? So, we had a new standard. As David said, it was needed, and now we have a standard that moves us above the any or above the sum and closer to the meaningful end. Now, the Supreme Court also said that the idea that our IEPs have to be reasonably calculated, that reflects a recognition that when we craft an appropriate program in our IEP, that requires a prospective judgment of us as educators and parents. And the Act contemplates this fact-intensive exercise going to be informed by our expertise and also by the input of the child's parents or guardians. And any review of an IEP must appreciate the question is whether the IEP is reasonable, not whether it is ideal. So that's our new standard that we have to live with. The IEP must aim to enable a child to make progress. After all, Chief Justice wrote in his opinion, the essential function of an IEP is to set out a plan for pursuing academic and functional advancement. So what's our responsibility as educators in writing our IEP? One of the things the court did is they referred to this term, which we talked about early on, ambitious. And they noted that the idea itself is an ambitious piece of legislation. enacted in response to Congress's perception that a majority of handicapped children in the United States were either totally excluded from schools or sitting idly in classrooms waiting for a time in which they could drop out. And if we, members of the Supreme Court, did not elevate the standard, we would be doing little to remedy the pervasive problem that caused Congress to act back in 1975. That is, that kids were excluded. And remember, and David said this, back in 1975 when the idea was first became law, the Education for All Handicapped Children Act, it was really about access. And the court recognized that in subsequent reauthorizations and amendments to the idea, it's become more than just about access. And now it's really about progress. Also, in a quotation specifically about the IEP team's responsibility, with regard to progress, the courts focus on the child's circumstances because, as the court said, the particular child is at the core of the idea. So we have to focus on a particular child. As David said, progress is going to be different for every child, yet that is the standard we now go by, is the child making progress. Now, in terms of the difference between kind of the Rowley case and the Endrew cases, remember, Amy was able to make progress in a regular classroom. She was able to do quite well. But students with more significant disabilities, like Endrew, need more than that. Just passing marks or going from grade to grade is not going to be sufficient. So when David spoke about Drew being he's more typical of the children that we have to be measuring progress. And one of the things David mentioned is, in the Endrew case, the school was not measuring Drew's progress. And they were not reporting to the parents. Yet we have to do that. Now, with regard to students whose difficulties prevent regular classroom integration or learning on grade level, that's what the new FAPE standards means, is that we have to write IEPs that are appropriately ambitious, that allow children to make progress in light of their particular circumstances. And as the Supreme Court said, every child should have the chance to meet challenging objectives. Now, they did, however, a couple things the court did. Remember, David said the parents were asking for maximizing progress, doing very well. And the school district was essentially saying, no, this low standard is fine. It served us fine over the years, so we can keep the low standard. So what the court did is essentially acknowledge that there's a difference between kids like Amy and kids like Drew in the amount of educational programming that they need. But they did also not go as far as to say maximizing progress. But they said we do have to make progress appropriate in light of a child's circumstances. So essentially what they did is they found a kind of a middle ground between that maximizing progress, the best possible education, and a some or trivial benefit. They sort of charted a middle ground between those two. So in reviewing the Rowley FAPE requirement, the High Court did not accept that real high standard. Instead, what they did is they found this middle ground between the high standard and the really low standard, but nevertheless saying that IEPs must reasonably calculated to enable a child to make benefit appropriate in light of the child's circumstances. Now, that was essentially what at the end of the case, although because the Supreme Court vacated the case, it had to go back to the circuit court and the district court. And in both, let's see, last year, the district court heard the remand and overturned their previous decision in Endrew and decided that the school district, in fact, had not provided Drew with a FAPE because they did not meet this new high standard of the Supreme Court, and subsequently awarded $1.3 million to the parents for tuition reimbursement and attorney's fees. And so that's kind of where we are in terms of what we need to provide to the students with whom we work, in inclusive settings or in our self-contained settings. That progress is the new watchword that the Supreme Court gave us. Now, there are a lot of different areas that we also have to consider with respect to what the Endrew means, and one of them has to do with least restrictive environment. And so we put some definitions up here, and David's going to come and talk about a few of these definitions, and then we kind of want to open it up a little bit, I think, for some discussion.
And what's interesting also about this, and I appreciate that nice summary there, is Supreme Court justices matter. The decision in Endrew was an 8-0 unanimous decision. There's not many unanimous decisions. One of the persons who heard the case at the 10th Circuit, the court just below the Supreme Court, his name is Neil Gorsuch. He's one of the authors of the decision that said that the district was fine doing this, what we refer to as this low standard. When he was part of his confirmation hearings, at that time Senator Al Franken queried him extensively about his views on special education. And he said he was just following what the law said. It was a low standard. So do Supreme Court justices matter? Yeah, they do. So keep that in mind. All right? So back to this. We want to talk about how, and just for a few minutes, talk about just lay a foundation for just inclusion and activities relating to the least restrictive environment in light of what the Supreme Court said relating to Endrew. But I'm going to give some quick definitions and several things as a part of this. We will be happy to send you copies of this. We will also be happy, I'll give you how to do this in a minute, send you copies of the decision, which is actually a good read. Now that you've heard this discussion and you understand special ed, it's a really good read, kind of things like this. There's another piece that I'll be happy to send you is Amy Rowley, the individual who was the focus of the case back in 1982. At the 25th anniversary of this, wrote a personal narrative about what it was like to be the focus of that case. She's now a professor in the California State University system, teaching deaf ed. And then another thing I'd be happy to send you is a piece that we wrote for the journal Teaching Exceptional Children that came out about a year ago that kind of summarizes these things. So I'll give you how to do that. So actually, let me give it to you now. Let me give you my email address.
It's on the first page.
So, yeah, but I'll just give it to you again. Yes, yeah. We'll come back to that. But just give, it's DFBATE. It's DFBATE at ship.ship.edu. It's DFBATE at ship.edu. You don't have to send anything. All your subject just has to say, send Endrew stuff. You don't have to say anything glorious or grand or have a pithy quote or anything like this. Just send me that and I'll respond to it. I'll do that tonight. All right? And just it'll be several attachments as a part of that. Okay? Just to let you know that there can be material that could be used in any other way. We'll also send you a copy of this presentation as a PDF so that you'll have this as information. Okay? So back to the definitions here. Okay? And there has been a change. And these things do not mean the same thing. Okay? Except for the top one and the bottom one. The other ones do not mean. Let's see if you guys are awake. All right? Okay? But it's interesting about this is they don't often mean the same thing. So when we talk about this, least restrictive environment, okay? I'm just going to, we'll lay the foundation for this in a second, okay? To the maximum extent appropriate, children with disabilities are educated with children without disabilities, all right? And only when the nature of the severity of the disability requires this to be removed. You think this is one of our new definitions? You weren't even alive, all right? So, okay, so, but it was 1977, yes? So it was basically when the law started. We've been living, this is the law since the get-go. This is not new stuff. Some people talk about it as new stuff, but it's not. So this is the law since 1977, right? Wait, there's more, okay? Continuum of LRE, okay, wait, hold on. Look at the date. This is the refresher course for you on this, okay? Continuum of all, we have to have a continuum available. What kind of services are needed for this? Having to educate some schools about this, right? Okay. But placement will be different for each child, okay? We should be most normal environment should be not be based on the label. Oh, please, please, if you hear people saying they have to go to the class for kids with LD because they're LD, no, that doesn't mean this. It's not based on the label, it's based on the needs of the individual child. And I say that, I do a lot of training for principals, a lot of training for administrators, and many of them have never heard that. And that really frustrates. And the school board members, who knows what they know, okay? The book we're doing for them, the joke about the book we're doing for them is it's going to be in large print with a lot of pictures, right? Okay. More physical education placement options, things about this. I'm thinking about this, is that for some kids, I put this as just an example, because we thought, which is often we include, just want to give you one option, okay? It's consult from adapted PE, consult otherwise, part-time regular physical education, but there's a variety of different things. You have to think about all the different options. Often we get reading examples. I wanted to give you something different, all right? More, okay? Okay, more. Mainstreaming, okay? Now this is CEC's definition of mainstreaming in 1975, an oldie but a goodie. I was in elementary school. Yep. So, but yes, you can see this. Process of placing children in regular education with appropriate service based on the IEP, most appropriate education, uniting general and special education. Wouldn't it be nice if we were doing this? 1975. We've been striving. We still have a ways to go. We still have a long way to go. Okay? Regular Education Initiative. Some of you don't remember 1986, but it was a good year. It was engaged. All right? But I share this with you, right? But I share this with you as a way of trying to consolidate the system. Madeline Will, who's a secretary of the Office of Special Education Programs in Washington, herself a parent of a child with a disability. At that time was married to George Will, the pundit that you used to see on Fox, but it was often on ABC. Okay? He also a parent of a child with a disability himself. But increased instructional time, shared responsibilities, things like this. You can see the evidence of how things have changed about this. We're trying to change the attitude. But it was called a regular education initiative. I don't know why, because it was a special ed doing things differently. Regular educators didn't do much different. Okay? More perceived problems. Again, oldies but goodies. LRE legitimizes restrictive environments, things like this. You can see confuses segregation. But we've been wrestling, you can see, I put in these up here because I want you to show how we've been wrestling with these issues, okay? And not always winning, okay? Inclusion, placement more in the homeschool, okay? Basing these services on age-appropriate regular education classrooms, using the principle of natural proportions. I was in a classroom last week where 22 of the 25 kids had an IEP just because it worked out scheduling-wise. And what's so interesting about this, you'll appreciate this, all of those kids had priority seating close to the teacher. We proposed stacking the desks. Okay? We actually set the classroom in a U-shaped format. And so it works well. Teacher walks up and down. Those three who don't have priority seating, we sit out in the field. Okay? Okay, providing supplementary aids and services, what's necessary for them. Okay, viewing special ed as a service, not a placement. Too many people think once you're identified as eligible for special education needs, you have to go to this special ed place and be in the special ed school or special ed. Yeah, anyway, all right, you understand what I'm talking about. Okay, more on inclusion. Supplementary aids, what do we mean by this? Special equipment, special instruction, peer groupings, personnel, whatever we need to do to provide supports for these kids. That's very important. We often negate this, and we often don't include this as a part of this. Okay? But the other thing, and I put this up last, is it's individualized based on the child. You may not understand what the I of the IEP stands for. You're going to learn something here. It stands for individual. All kids don't necessarily get the same thing. We have to make sure it's individual to the child and talk about this and emphasize this. Right? More. Right? You thought that really? Okay. Individualized programming, long-term, top-down programming. I'm working with a school district right now that has great services for kids at the elementary level. And then they get to the middle school level, they just don't have the services. So all these kids get cured at the end of 5th grade. And we're finding that some of these kids are having behavior problems. Who's the slow learner here? Okay? Right? All right, instruction priorities, curriculum content, and then individualized determining instruction. Individually determining the instructional needs of these kids. This is the vital part of this process. Now, as a result of this, we've had some decisions on this, all right? But we'll get to the decision. Placement will be different for every child. Just because the kids have the same label doesn't mean they get the same placement. Right? Pay attention to this, is the individualization. The Supreme Court and Endrew talked about the individualization necessary. Yes, he ended up going to a more restrictive placement, but it was based on his individual needs and the fact also that the school district was doing a crappy job. Okay? Placement should be the most normal environment where the child can succeed, where the child can be successful, and talk about this. So back to what we were saying about Endrew, is the expectation is kids are to make progress. They're not just, the big thing, they're not supposed to just get benefit, they're also supposed to now make progress. We are to report on this progress and determine this, right? And should be based not on the label, all right? I'm gonna say that over and over again redundantly, repeatedly, a few more times, okay? More. We've had some cases relating to LRE. You can, if you look at these dates, some of you were not born by these dates. Again, no show of hands because it just frustrates us. Okay? But you can see some of these things here, and I'm just going to talk about just some basic facts from each one of these. Then we're going to open up for questions because there's some basic things that are common that you need to address. Right? And I actually dealt with this one after this kid. This is when I'll talk about that in a second. All right? Case law, principal support, Ronker from 1983. Again, remember, put it in historical perspective. The law had just been passed. Actually, he spent some time with the father of this case. It was really fun at a race. I didn't know he was that. Okay. What makes the special education so special? What is our special sauce? I ask undergrads that, and they often, it's because we are special. Think about this. This is actually a really hard question. What is so special about what we do? Is it because our classes are smaller? Is it because who knows, all right? But here's the question, what is so special about the special education placement? What is so special? And okay, can that special thing be brought to the regular education classroom? That's a question that we don't often ask, but we need to. And what are the benefits of the child? How disruptive is that? We often don't ask that, okay? Daniel R.R., okay? Can education in the regular classroom with supports be achieved satisfactorily? Okay? And if it can't be mainstreamed, what can we do to get the kid to participate as much as possible? I'm working with districts right now where they're pulling kids out for everything. And they're not thinking about, let me give you an example. I'm working with a district right now that every single kid at this elementary school gets a free breakfast. But all the kids eligible for special ed have to eat at the special ed table. Everyone else gets to mill in, mill around, play paper football, Pokemon cards, and fidget spinners. Whew! Yep, they have to keep in contact with them though. But but they can sit anywhere else. But if you're in special ed, you have to sit at the special ed table. Why? Because 6 years ago, one of the kids was in a fight. That kid hasn't been in the school in years, but it's now the policy of that district. So I said, why? And so actually what the complaint came because the special ed the teacher has to be there every morning to sit with the kids. While all the other teachers kind of do things, hang out in the teacher's lounge, pull in late, drink coffee, and have adult conversations, the special education teacher was pissed. Why do I have to be there? There was no reason for the teacher to be there. Now the kids are at least mill around with everyone else. Just every single instance, think about these things. This was just a few weeks ago. This is not old stuff, all right? Daniel R. Moore, okay? Did the school district take steps to include the student? We often just automatically think the child is supposed to go, if they're going to go to special ed, we're going to start really restrictive, and then we're going to spend time in the more restrictive placement, and then when we fix them, not like I recently did to my cat, but when we fix them, then we're going to let them come back to the regular education classroom. That was the intent of this, right? Will the student receive benefit, or are there negative effects on other children? That's a good question, all right? Other important cases, Greer out of Georgia. Are we predetermining this? And thinks about this. are we predetermining the kid needs to go to this? I mean, I do a lot of workshops for special education administrators. Often they come in with, here's your child's IEP, and here's your child's schedule. Here's what your child's going to take. We haven't even started talking about anything, but they've already predetermined everything. Many of these things actually smack of predetermination. Okay? Birdie, which is a really interesting case. When little Raphael was in kindergarten, he lived in New Jersey. He then moved to Pennsylvania. I had his case later as a hearing officer. So they're also arguing inclusion at that point when he was 17 years of age. Right? But burden of proof, just because the kid, little Raphael, I know about this kid because I've met the kid. He had Down syndrome, and the school district said, if you have Down syndrome, you have to go to a special school, which was located in a separate district. That was before they allowed him to set foot in any building in the district in kindergarten. When he went for the pre-kindergarten screening, you have to go to a separate school. They did nothing to assess him, nothing to determine, nothing to provide any programming, nothing about this. Districts are still doing things like this, folks. Districts are still doing things like this. All right? Okay. Another important case out of Sacramento. Okay. Educational benefit, effects on teacher and other children. And another one, kids with really severe behavior problems. What can be done about this? What are we doing as a part of this? As opposed to just automatically pulling the kids out, are we doing anything to try to include these kids? What steps are we doing? I consult with a lot of districts, and I bet many of these districts would be really happy if I just pulled up in front of them, their buildings, with a big van and saying, give me all the bad kids, I'll take them away, you'll never see them again. I could probably make a lot more money. Right? But what I ask is, what pre-referral interventions have you tried? What behavior techniques have you tried? How many times did you try this? I mean, I've seen teachers try proximity control for 20 seconds. That didn't work. Right? Yep. And or not trying it, or not having any kind of fidelity as part of these kinds of things. So we'd have to think about how we're actually doing this and implementing these things. Right? So okay, we're going to talk about this when we get to questions, but you can see about this. The question you need to ask, and we need to make sure people are asking this as a part of IEPs, and Endrew really kind of clarified this, is how are we going to get kids to make progress? Then talk about where. And then keep that question in mind. What is so special about the special education program? What is that special sauce? And what is that? And can that be reasonably replicated in the general education classroom? And many times it actually can. And many times it can. And we need to think about this, but we often don't think about it that way. And that poses a significant problem for some of these kids. And we're actually placing kids in more restrictive placements when they don't need it. And it's encouraging teachers to refer kids out. Now, one of the things we're having is, this is more of a nationwide problem than just only Indiana, is we're doing value-added measures of teachers' performance based on scores. We pushed for inclusion for years. You can see how these cases have changed. Some of these kids who are eligible for special education will lower the scores of some of these teachers. And these teachers are saying, I'll take any kids you want in their building, as long as I don't have these kids. And that's posing a problem for inclusion. It's posing a problem for adapting materials. It's posing a problem for teachers wanting to support kids. So some of these teachers, in fact, I don't fault the teachers for this. I'm not faulting the teachers. It's just the way the incentive system has been established. They're becoming very trigger happy about referring kids out. And we need to think about ways of incentivizing teachers to actually still include kids with disabilities, still take the tough kids, still take the kids who may not make a year's worth of progress, who may not make what we used to refer to as AYP, or annual yearly progress. We need to think about ways of incentivizing this. Keep this in mind when teachers complain about this. Keep this in mind as teachers talk about these issues. And again, I'm not faulting the teachers for this. It's just the way the incentive system is working right now. But it's almost a backwards way. It's almost slapping us back down to almost wanting to have kids excluded more. And that's posing a problem because we've been making such progress. My daughter, who's in college now, we've just talked about her before, she's a junior in college. When she went to kindergarten, she had a kid, because of alphabet, sat next to a kid with autism. Okay? And she sat with that next to this kid for 3 years, because that's the way the alphabet works. Okay? It doesn't change. And she said, but she thought that every kindergarten classroom across the nation, there was a kid with autism. It was completely normal for her. It was completely expected. She knew nothing different. She didn't know this. She didn't know how it was the parents had to fight to get this kid in there. It was a big deal about this. This was normal for her. So for many of these kids growing up with this is their normal. For me, it was not. Right? I graduated from high school back in the early 80s, and when only kids who were eligible for special ed, they were served in separate buildings, actually portable units outside of our buildings. Right? Outside of our buildings. They didn't participate. They didn't even change classes at the same time as we did. So I had no comparisons, no expectations of this. It was a very separate world. We've changed attitudes, and we've changed teaching. We've improved things. But also, we need to keep this in mind as we talk about this as part of the implementation. How are kids still going to make progress? Okay? So that's pretty much all we have right now. We want to take your questions. And the promise has been made to us. You've made this promise. We will answer the easy ones. She'll answer the hard ones. So any question about this case or other cases, or just inclusion as a part of this in general, we're happy to take those. So fire away. If you've got a kid who, yes, you're by law, you've got a kid who moves into your district, you take that previous IEP, and you are obligated to implement that as it is written, as if you wrote it. So if it says this kid is supposed to be getting this, you give them that, right? This is advice for you. If you know a kid's moving to a district, and you don't like that person, write an IEP where the kid is supposed to get transportation to and from school in a gold-plated limousine with a chauffeur named Tom, and then that district has to implement that. All right. So, but paybacks are hell on that. So be careful. All right. But what I'm recommending to districts, okay, and working with districts, you got a kid who comes into a district, you implement that IEP. But at that very same time you implement that IEP, you ask for the opportunity to reevaluate the kid. Because you actually have no data whatsoever about can you move the kid to either a less or even more restrictive placement or keep them there. So you may not have to do the full shebang of the evaluation, but at least over that time you can get some assessment data, you can get some observation data, and then at the end of that 60 days, you now have the window available to make a determination, yay or nay, about whether this kid needs there. If you don't have that kind of evaluation data, it's just kind of more hearsay kind of stuff. So ask for the permission to evaluate at that point, then move on from there, reevaluate things, and maybe just be a paper reeval with some observations from the teachers, because maybe the kid has some really good testing data that is within a reasonable time frame. But at least review that. And then that gives you also permission to change placements and programming and also revise what's going on about the IEP. You can do these things. But yes, take the IEP, whatever's written, you implement that. Okay? It's not, because I think I said earlier, smacks of predetermination. It's already been predetermined by another team that that's an appropriate program for the kid. You just have to implement that. Whether the kid, and some of you, if you get these IEPs from out of state, good luck understanding what the heck they mean. Okay? I mean, how many, have you ever seen IEPs from Texas and the whole ARD process? What the hell does that mean? I can tell you what it means, but I can't interpret what it says. But it's interesting about this, you have to implement it just as if you wrote it. It doesn't smack of predetermination. I think that's what you were thinking about, that you've already made a decision, this is what the kid's going to get. No, the other team and the parents have signed off on that. So keep that in mind. Does that answer it a little better?
Well, I get it.
So in essence, basically what you're saying, what is our responsibility regarding the other students?
And I'm a principal.
Well, and that's a very legitimate consideration, obviously, that you have to be considering the safety of others too. That's probably as difficult a question, I think, as
well, that's why I wanted her to
schools are.
take it.
Oh, okay.
No, it was one of the things about this is if you looked at, I'm sure, look at triggers, look at successes, look at their antecedents that. Look at the antecedent kinds of things. Look at if there's other ways of keeping him busy. But there's a word that you used that I need to emphasize as a result of the recent Supreme Court cases. You said, "What's best for him." Our obligation is not to do what's best for him. Our obligation is to do what's appropriate. And if we had to do what's let me give you an analogy.
I need to hear this.
Let me give you an analogy. Is you have a kid who lives 20 miles from school. What's the best way for the kid to get to school? A bus. All right, let's go better. What's better than a bus? Parents' car, what's better? What? Limo, better. I'm sorry, I see some, all right. Helicopter. All right? Our obligation is not to do what's best. Our obligation is to do what's appropriate. And best would be a superlative race that you would never, ever, 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 that sounds like a line from a song, never win. You would never win. So, no, and I appreciate your frustration about this, is that this is a kid who's, you're trying to include him, you're trying to encourage what's going on, but you need to look at all the factors of what's going on. Do certain things set him off? Do certain things work with him? Do better positions in the room work better? Are there things we can have maybe stim with that might prevent or keep him busy? Are there other things, all these different things? There's a variety of things we have to look at as a part of this. But we, again, back to, we're not,
Whole jewelry box full of jewelry.
Good.
Just his own.
Good.
It's his own.
Yeah.
I mean,
Wha-
yeah.
I'm working with a kid very similar to this. He basically has a 2-liter bottle that he spins on his finger, and when he's spinning that on his finger, when he's on the bus, he's fine. When he doesn't have his 2-liter bottle, who knows if he's going to get to school that day? Because he attacks the bus driver. So, and it really poses a problem. So there's multifaceted layers of this that you have to think about. Yes, you have to think about the others. And you need to think about the others because your obligation is safety. And I can speak to this as a parent. As it speaks as a parent, my daughter, when she was younger, had a bone density issue. And there was a kid who frequently liked to punch others. And he punched her one time, she broke her arm, right? Broke her arm, right? And she was really good about it. Oh, he punched me, this cast color is green. My next one's gonna be blue. After that, it's gonna be red. She wanted the rainbow of cast colors. Those suckers smell. We weren't gonna build it for her. But it's interesting about this is you have to think about the safety of these issues and safety of these other kids. And I'm sure that you have to think about, is it too disconcerting? Is it too much? And we didn't talk about this, but one of the cases looked at, is the behavior so severe that it's preventing others from learning? You don't have that in this circuit to look at, but it's one of the other circuits. And I think it's one thing we have to think about. But behaviors are one of the hardest things we do. It really is, because you as a principal understand this. You have to keep everything calm. And if there's a bubble that rises, it's like whack-a-mole. If there's a bubble that rises, you're the one who's responsible for keeping things calm. And that poses a problem because many principals don't have a lot of training in special ed because people don't stay in special ed long enough to become principals. And so I'm not telling you anything. Special educators have principals. PLES. Some of you are laughing at me for that one, but I just want to make sure I got that right, okay?
Do you have other options? Can you, I think David's probably referring to the California case, Clyde KVPL, and that involved a child who was choking other children. And they had to move him to a special program. But you don't have that option?
You do what you have to do. Mm-hmm. The hard part is, ready, I'm going to piss you off, is whether you have it available or not, your district has to have a full continuum of services. So if he needs a more restrictive placement, your district has to find it. And yes, it may be a really small, and most of the districts I work with in Pennsylvania are really small districts. I'm working with a district right now, you guys should consider this. The elementary, middle, and high school are all one building. It saves on busing costs. You should try that. So yeah, but but you have to think about some of these small districts. You have to find the services available. Maybe it's conjunction with another district or consortium with other things out there, because I'm sure there's other districts who have similar issues. But you have to have it available. Okay. I think we have time for one more question. Yeah, I'm sorry.
Well, I think at its heart, as David said, our program is, special ed was created by a federal law, the idea. And who were the people that essentially created the law? They were attorneys. And what attorneys always do is the way you solve problems is through dispute resolution. And if we can't come to a meeting of the minds at the IEP level, that's when the dispute resolution comes in. That's where, when you talk about the Rowley and Endrew case, they all started at the IEP table. And we were just not able, the parents and the school authorities for some reason were not able to come to a decision about Amy or Drew's education, and then they moved into the dispute resolution system. That's kind of the way special ed is set up.
The other thing is, for state compliance, it's a lower standard than it is for litigation. There are many districts who've gone through just doing fine when they're under compliance monitoring, but then they go to litigation, the kids are not making progress. And so the compliance looks at, have you followed, basically crossed the T's and dotted the I's and had the right people in the rooms, kinds of things. It doesn't look more at the second prong of what we look at is a substantive benefit for the child. So that's the issue. And that's posing some problems because I'm working with some law firms that are thinking about coming to your fair state, by the way. And what they do is, and a law firm near me does, what they do is they advertise in the, two things. They advertise at the local library, we'll do for the parents a special education workshop, a free special ed workshop, and then this library, in order to justify its space, advertises for the law firm. They do a half hour on what is special ed law, then a half hour how to sign up for their services. But they also then go into cities, and then they run out a wing of a restaurant, and they do beer and IEP night. Bring us your IEP, come and get all the beer and nachos you want. And if they find just one IEP that is questionable, they've made their mark. They've got what's in. Then they ask, do you know other parents we can talk to? So it's coming to a city near you. Stay tuned.
But I would say too, if there's anything that the Endrew case really teaches us, it's about the importance of data. That we really have data to show we're making progress, that we have data regarding the assessment that we're doing, so we, in essence, have a kind of a baseline measure of the child, and we measure frequently and report it to parents and make decisions based on that data. I mean, in the final analysis, if we have data that shows that a child is making progress, we almost have a bulletproof IEP. I mean, that's because that's the new standard, is progress.
Well, one final, building exactly like that. I was involved in 85 due process hearings last year. 79 of them we settled within a very short time because we didn't have data. We now have data in those districts. I've slapped districts because because for me, special education litigation is not the price of doing business. We need to learn from this so that it doesn't happen to other kids. So, okay, all right. Thank you. We'll be happy to take more questions.
Thank you.